Before we get started, we wanted to thank Liberty Mutual Surety for sponsoring this episode of Let's Get Surety. Liberty Mutual Surety provides contract and commercial bonds for all size companies and contractors around the world. Liberty Mutual is here for you today, tomorrow, together. For more information on Liberty Mutual's breadth of surety products and solutions, visit www.libertymutualsurety.com. Now on to our show.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks so much for joining us for this episode of Let's Get Surety. I've got with me today my co-host, Mark McCallum, CEO of NASBP. Hey Mark, thanks for being on.
Hi Kat, I love to be here.
I know you do. And you're excited about today's topic as well, I'm sure.
It's a fascinating topic and something I think a lot of people probably aren't thinking about, and they should be. So
we're going to be looking into the Government Accountability Office and the bid process or bid protest process with the GAO. So to do that, we've got with us today David Timm. He's a senior associate with Burr and Forman. Hey, David, thanks for being on.
Good morning. Thank you, Mark and Kat, for having me.
Well, David, before we dive into talking about the GAO project bid process protests, can you just tell us a little bit about your background?
Yeah, thanks. I've been doing claims and bid protests for my entire career. I started working for the Transportation Security Administration when I was in law school at GW, which is the premier government contract law firm in the United States. Or, excuse me, the law school. Yeah, exactly. And so I've really spent a lot of time, in the milieu of government contracts. And one of the things I find most interesting in the space is bid protests. And so I spent a lot of time writing and thinking about it. And I've had a couple of good opportunities in your field. I worked on this really important case for your profession called the Tojiak case at the Court of Federal Claims. And actually, I wrote about it for Surety Bond Quarterly a couple of years ago. Myself and a couple of other attorneys at my firm, Joe Cohen and Dirk Hare, litigated that. And it was a really big result relating to whether a wet ink signature was necessary.
Yeah, it was a good result. We like that.
Yeah.
Yeah.
And we'll make sure we include a link to that article if anyone wants to check that out and see what you guys had to say about the Tojiak case as well. So, and today we're going to, first, let's talk about what bid protest looks like generally, just so we can give people a framework before we dive in deeper. So how would you explain the bid protest process?
Yeah, so a bid protest was when a disappointed bidder doesn't receive the award for a government contract. And when I'm talking about bid protests, I'm talking about it in the federal context. There are bid protests at the state and local level, and those are interesting, but they're their own animal. And so today we're focused on federal.
Federal, okay.
Yeah. Great. And so bid protest, it doesn't necessarily have to be a disappointed bidder, although that's probably the most common. Okay. So there's also these protests that take place before the solicitation is awarded. And those are pre-award or pre-bid protests, and those challenge the terms of the solicitation. So let's say it should have been a set-aside contract, or you believe that it should have been a set-aside contract, and you have some other issue with the way the solicitation was crafted. There's maybe some ambiguity in it, and you go through the RFI process or the Q&A process, and the government's not responsive. So you can go to the Court of Federal Claims for bid protests. You can go to the Government Accountability Office, or you can go to the agency itself. And the way that I like to think about those three different forums is you have the Little Leagues, which is the agency, and you have the minor leagues, which is the Government Accountability Office or GAO, and then you have the major leagues, which is the Court of Federal Claims. And I can talk a little bit more about why each falls into that category if you like.
Yeah, that'd be great.
Yeah, very helpful.
Yeah, so the agency, I think people will get this really intuitively. When you bid protest at the agency, it's supposed to be reviewed at a level above the contracting officer, which makes sense, right? Just for a little bit of objectivity. But we're still talking about the same agency that's procuring the project, right? Mm-hmm. So I think people intuitively and correctly understand that the process for review is going to be much less. It's going to be much more deferential to the decisions that the agency has made. There's also much more limited, if any, discovery during the process. So that brings you to the GAO, where it is an independent agency, right? And it's a creature of Congress created. Right. They do a lot of other things besides bid protests. But one of their main functions is to review bid protests. And they do it in a very quick way, especially compared to most other types of litigation. So GAO has a statutory mandate to resolve them within 100 days. And in addition, there's something really that a lot of protesters find very useful, which is the automatic stay of contract award during the pendency of the bid protest itself. Now, I think that GAO is a good forum and I use it regularly. It has a couple of other advantages. It's very like the agency. It doesn't take that much money to litigate there unless it's an incredibly complex bid protest. Part of that is the time limit. Part of it is there is less discovery at GAO as compared to the Court of Federal Claims. So then we ask ourselves, why minor leagues versus major leagues? Well, just the process of filing at the Court of Federal Claims compared to GAO is much more technical and pleading heavy. So while you can go to GAO, and we'll talk more about this later, as a pro se or without an attorney, it's very difficult or impossible in a bid protest context to do that at the Court of Federal Claims. And all of those extra rules and requirements and things you need to know that aren't obvious make it much more expensive from the litigation side. But the reason that it's the major leagues is not only because it costs more and the reasons related to cost, but it also, although they're interpreting the same federal acquisition regulations, neither one is bound by the other. So they end up with these interesting splits in decisions on identical topics. A good example is the key personnel requirement. At the Court of Federal Claims, if you change key personnel, they don't care if you change key personnel and you don't inform the agency. But the GAO, if you do that, you'll get the opposite result. You'll lose. So, there's lots of examples like that. But in almost every case, and I've written about this a few times, the Court of Federal Claims is better for contractors. So that's sort of the hierarchy there.
Trying to use your baseball analogy, is there a certain batting average or success rate depending on the forum here? Yeah,
that's a good question. So GAO is the most transparent about its results. And also the majority of protests in the United States are brought at the Government Accountability Office. Last year, there were about 1,700. And when you consider corrective action, which means that the agency admitted something was wrong and, maybe they changed the solicitation or maybe they award it to the contractor who protested, and sustained decisions where GAO gets to the end of the process and says, yes, the protester was right. Those two, corrective action and sustain, are 50% of the 1,700, plus or minus every year. It's for the last 10, 15 years, it's been around 50%.
Kind of that range. Yeah. Wow. So sounds like it would behoove a government contractor to really get a knowledgeable attorney, because they really need to think through their strategy, it sounds like, in picking the right direction for their bid protests. Would you agree with that, David?
Yeah, and I like to tell people the majority of the time you come to me and you say, I'm disappointed. I didn't get the bid. I didn't get the award of the contract, and I'm upset and I want to bring a protest. I would say 8 or 9 times out of 10, you come to me, you tell me the facts, I look into it, and then I tell you, save your money for next time.
Well, so let's say, there's so many tools out there now, and you've got AI, for example, where you can find information and it can really help you. What happens if I want to do it myself, using AI as a tool for me to try to figure out where I go with my bid protest? Are there any problems with that?
Yeah, thanks for teeing me up. So I wrote an article in August on this. And at the time, I think this was early August, there were 4 decisions that were public at the Government Accountability Office that specifically mention, either in a footnote or in the main decision, some issue with fabricated or non-existent case citations in the bid protest itself. And in all 4 of those cases, and since then there have been 3 more, so there's 7 total that were published. In all those cases, it was a pro se or a without legal representation protester bringing the claim. And in each case, although GAO warned the protesters that they could sanction them, they dismissed all of them on other grounds for other reasons. So to me, the way this reads is GAO is getting a little frustrated, and they're concerned that, I think the language they use is it's undermining the effectiveness of their process to include these AI generated citations. And so, GAO, I think they're sort of shooting a warning to all other potential protesters to say, hey, maybe pump the brakes a minute before you use AI to generate your bid protest.
Well, I'm sure, people didn't realize that they were giving false or incorrect information. So what is it about AI in particular that, people need to be cautious about?
Yeah. So I don't think I mentioned this at the beginning. I have worked with a lot of legal specific AIs in my career over the last couple of years. And I'm currently the co-chair of my firm's AI committee at Burr and Forman. And so, I do have like a nice little extra bit of perspective on this because I've seen a lot of different demos. I've used a lot of different, especially legal specific AIs, and I've done a lot of independent research into it as well as part of my position there. So AI has a couple of different issues when it comes to generating legal stuff. Now, okay, if you want to use AI to rewrite your email or send a text to your mom that's conciliatory because you can't stomach it, then there's not really a big problem there. But when we're talking about legal specific issues, we're getting into things that are nuanced, and there are difficult questions of interpretation, both of the federal acquisition regulations as well as the precedent for these different forums. And like I mentioned earlier, Court of Federal Claims, GAO, they come to different conclusions. So it's very easy for these programs to essentially give you a false sense of confidence in what it's generating. And that really comes from the fact that it all looks so plausible, right?
Right.
When it spits something out, it's not going to be typo written. It's not going to be written in a clunky way. I'm going to say a few phrases on this podcast because we're live, and it won't be perfectly formatted sentences. It'll be conversational
because we're human.
AI is not going to do that for you. Yeah. And so when you're looking at it, especially as somebody who's not experienced in the area of bid protests, you're going to go, oh, yeah, this is great. This is amazing. And in fact, it supports exactly what I wanted to say.
Is it advocating for you, right?
Well, yeah. And I think a lot of this has to do with prompting, but there's this feature to many of these AIs, and, OpenAI has acknowledged that it has what they call a sycophancy problem. So I picture like, a cartoon villain, and then you've got his minions, right?
Right.
And the minions are always going to say, yeah, you're right, boss. Like this is the greatest genius plan to take over the world. And so the AI, especially the popular ones that are out there for use, they happen to be very sycophantic. And in that vein, trying to please you, you say to the AI, help me craft a bid protest that, justifies why I should get the award of the contract. And these are large language models. So occasionally I'll talk about them as LLMs. The LLM will basically internally go, okay, I got to please the user here. So let me try and find some plausible looking words, phrases, even cases. And this is what we're talking about at GAO that align with what the user wants.
That's kind of scary.
Yeah,
I mean, I think people don't realize that you're going to a yes man when you're using your AI platform. That's really interesting.
And it's because it's so plausible, I think. And because if you're not an expert in the area, it's very difficult to detect these. And they're what we call hallucinations. So when GAO is referencing potentially sanctioning protesters for these things, they're talking about either fabricated citations where it's just made up from whole cloth, right? Or an inaccurate reference to a citation. For instance, there have been a number of specific cases that they've discussed where, for instance, the B number or the case reference number is just incorrect. And so when you go and try and look up the citation, you don't find it, right? And let's remember what citations are for in this business. And in bid protests, precedent is very important. And same thing with citation to, the regulations. And if the citations are incorrect, they're not guiding you to where the authority is. And so everybody spends up a lot of time chasing their tails going, okay, I can't find this case. Did they make an honest error? Did they do a typo in the B number or is this something else? And in a lot of these cases, I think it's going to be these large language models.
Well, and I can see how, I as a layman looking at that wouldn't notice that a case citation is incorrect or that it's just a case that's completely made up. So in trying to be a yes man, the AI will, if it doesn't find an actual case, it'll just make a case up. Is that what you're saying?
Okay.
That supports you?
Yeah. So I that's yes and no. There's like a couple things working together here. And let me sum it up in a couple different problems, right? So you've got hallucination, which is an issue with all large language models right now. So for instance, you would think oftentimes people say to me, oh, well, okay, so maybe it's having some problems now. We're at the early stages of this technology, but certainly it'll get better in the future. One thing that we know from a lot of research over the last couple of years is these large language models have been advancing and they've been getting better at specific things. They've been getting worse at hallucinating. Essentially, the additional complexity of these systems, they're introducing things like chain of thought and reasoning models on top of the large language models. But the fact of the matter is that at the end of the day, these machines are pattern matching, right? They're looking for what's the likeliest next word following, the word that I've got selected. And so while they're doing a couple other things on top and ultimately, it still just comes back to this problem of they're guessing the next word. Unlike you or me, we're not going to hallucinate a case, right? We just can't do it. Why would you come up with something that doesn't exist from your memory? It doesn't make sense.
Wow. I mean, that's a little scary. And and you said, so the kind of yes man nature of what's going on. And then it sounds like they're very convincing. They're confident when they're providing this information, these large language models. Is that true?
Yeah. So I started to talk about the several primary problems in the legal context. First one is hallucination. Yeah. We've gone over that. We've also talked about sycophancy, which is the yes man syndrome. And then it is like a combination of plausibility and overconfidence or sort of an unwillingness to admit when it doesn't know, right? We're talking about a system that's guessing the likeliest next word. As much as people want these things and they appear as if they're thinking, they're not really thinking in the way that you and I think. And as a result, they end up saying things confidently and plausibly, and that lends itself to deceiving the user about whether they know or they don't know. A big joke here that I always make is lawyers will tell you to a fault, perhaps, it depends, or they'll have to put some percentage odds on whether your case is good or not. And the large language models are simply not good at uncertainty.
So even if you keep querying them, are you going to get a similar mistake? A certain, it will continue down the path, perhaps even of the made up information.
Yeah. So if you know or you guess that the citation is fabricated, for instance, and you challenge it. In some cases, I've had this experience. In some cases, it'll double down and it'll say, "No, this is
Really?
definitely a real thing." In other cases, it will do the sycophantic thing where it says, "Oh, you're so right. I was so wrong about this, and and let me fix it. Let me find another citation for you." But ultimately, even the best large language models that we're talking about here, even the legal specific ones that have access to the database, they're still hallucinating at rates of 17+% per 100 propositions. And so one thing that I think that, GAO is talking about sanctions in the context of citations. One thing that I think hasn't really been discussed as much is the fact that it's all facts, all propositions that have a chance of being hallucinated. So let's say that you generate a table and it has, different contracts that are similar in size and complexity to yours, and you're putting this in your bid protest. Well, there's a good chance that, or approximately 17 to 30% chance that in any given one of those tables, there will be a hallucinated fact or proposition.
Wow.
And that seems like too much of a chance to want to risk a sanction.
Well, yeah, I agree with you. I agree.
When it sounds like you said there are already 7 cases out there where this has occurred. So it's not like this is new to GAO. I can imagine you said sanctions, but just irritating them about having to deal with this. And from what you said, it's like, well, maybe it's enough irritation that they're going to find another reason to deny that protest.
Yeah. And so there have been 7 cases that are published. There's an 8th that was referred to, an unpublished decision that was referred to, because there was one case that came out a month ago, I think in August. And in the case, it said, "Oh, and by the way, this is the second time we've had the same experience with this pro se protester." And they referred back to an unpublished case. So we know about 8, I suppose. I personally can't talk about it, but I know about other unpublished decisions that have involved at least allegations of AI misuse. And it's interesting. I've sort of got a running, database, little spreadsheet for my own use. It's interesting, not in every case will the protester admit after opposing counsel or GAO challenges them that they're actually using a large language model.
Really?
But the thing that GAO says is it doesn't make a difference to them whether or not they actually are using a large language model, whether they're using another tool. The fact of the matter is that they're coming up with these inaccurate or incorrect citations, and that is undermining their process.
Can't imagine it's too helpful to that protester's reputation either. Particularly if they keep going down the same path.
Yeah, I mean, I totally agree with you. You make a great point that I think is really important here. It's about credibility in these situations. There was one case about a month ago, and while I wasn't familiar with that particular issue, another lawyer that I follow on LinkedIn wrote about it, and he said that he thinks that if they had a good attorney on their side and they didn't have these issues with credibility about the hallucinated citations, that it's possible that they might have been able to succeed on their protests. So that's not exactly what GAO said, but who knows? I mean, it's totally possible. The others were dismissed for a variety of other reasons, all unrelated to specifically sanctioning for the AI misuse. But again, in each case, they're warning and they're publicizing this so that others take note and consider their use before they get in trouble.
Go ahead, Kat.
Oh, I was just going to say, in the beginning, you mentioned that often when you're speaking with clients and they've brought something to the forefront that might be something they would want to submit as a bid protest, you'll advise them against it because of your expertise in that area. With the sycophancy of AI, it's not going to say that. So maybe some things are going forward that they could have saved themselves the time and trouble by not moving that forward if they had spoken with a trained attorney.
Yeah, no, I totally agree with that. And so, there's a sanctions case from 2016 called Latvian Connections. And because I've been interested to see whether GAO will eventually sanction someone for this misuse, especially in the pro se context. If an attorney submitted hallucinated citations, I think at minimum the attorney would be sanctioned in some way.
Okay.
Whether or not they would force dismissal for the client, I think probably doesn't make that much sense. But we've been seeing lots of different cases throughout other legal contexts besides GAO where there are these hallucinated citations and there are attorneys involved, and they do often sanction the attorney. Well, one of the big sanctions is they say the other side gets its costs for filing the briefs related to, pointing out that there are problems with the citations. Another one is, and this is sort of an embarrassing one, is you force the attorney to go and talk to all the other jurisdictions that they regularly practice in and their clients and tell them, hey, I was just sanctioned for AI misuse. That one's tough. And then there are some monetary sanctions as well. But at GAO, I mentioned this Latvian connection case. This was a pro se protester, and GAO said in that decision that they had filed, I think, 150 protests in a year or two period. And they were banned from protesting at GAO for the foreseeable future until they got, some sort of permission. And there have been other anti-filing sanctions against pro se protesters in the past, specifically at the Court of Federal Claims, not related to AI misuse. There hasn't yet been a Court of Federal Claims AI misuse case, but I think that's a possible sanction. And I do wonder whether, I mentioned there were 1,700 bid protests last year at GAO. I wonder whether the number is going to be quite a bit higher this year for the reason that it is just so much easier to file a pro se protest.
Well, it's a very competitive marketplace, right? So I was just in general, I was wondering if bid protests have increased over the last several years. Do you see that? No,
they haven't. And every couple of years, and this is ongoing right now, people come out with proposed legislation, or they complain about the number of protests. They say it really makes procurement less efficient, and it costs sometimes the incumbent or the agency additional money that wouldn't be otherwise spent. But GAO put out a report, I think in June or July this year, and they were asked by Congress to investigate whether a system should be in place whereby the protester who files a bad protest, one that doesn't have any merit, should be saddled with the fees related to the protest. So potentially paying the incumbent, or sorry, not the incumbent, the potential awardee that's getting delayed on their contract, or reimbursing the agency for its legal fees, things like that. GAO came out firmly against that. And one of the reasons that speaks to your question here that they did so is they noted that, there's so many procurements every year. And we're talking about GAO, 1,700. So we're talking about much less than 1% of all procurements are protested. There are a lot of contentious protests, and we do hear about the ones that are most egregious, that take the longest, that are most divisive. Right. But I think if you just recall, I mentioned earlier, sustained protests and corrective action, 50% of the time. There's clearly some signal here that when bidders bring a protest, something is being fixed, and the agency knows that they can be protested. And I think this ultimately contributes to the system operating more efficiently, more than it slows things down or causes expense.
Okay. I wanted to circle back on a question I have. And you had mentioned, obviously, that AI can lead to inaccurate information being proffered, that could lead to sanctions. What about privacy in the standpoint of you're using a large language model, you're putting maybe sensitive information in that to come up with your approach or your strategy? What does that do? I mean, where does that private information go?
Yeah, that's a great question. So it really depends on the large language model that you're using. But let's say that you're a free user of ChatGPT, which is made by OpenAI, and it's the most popular out there, or something like Claude. A lot of times these these programs, they send the data that you input into it and they use it to help train their model further. So the classic example, and this is what I tell people who are working with me, if you put things into one of these open models that go back and train the data, it's disclosure to a third party. So if you're working with me and I tell you something and you take that information and you put it into the large language model, it's potentially breaching attorney-client privilege. So that's one thing. Another thing is these systems are, they're very new, and there have been a number of interesting news reports where users who didn't think that they were sharing their, the details of their conversation, those conversations were getting indexed by Google.
Oh, wow.
And so they were essentially searchable for a period of time. I think they fixed this issue, but it just speaks to the possibility that these systems have vulnerabilities that can be exploited, either inadvertently or otherwise. And then, I think finally something that people don't really consider is that if you're in a dispute, those chats that are saved, they're potentially discoverable. So, let's move outside of the bid protest context for a minute, talk about like a claim. If you're taking information, about your case and putting it into a large language model, and the other side in litigation writes a discovery request that says all conversations relevant to the dispute with ChatGPT, you're going to have to disclose that. And Sam Altman, who's the CEO of OpenAI, has specifically acknowledged that that is true.
Well, I love that point about another reason to get a knowledgeable attorney, to have that attorney-client privilege as you go and you formulate your strategy and what you're going to do. Will any attorney do here, or do you need an attorney that really kind of focuses on federal government contracts and in particular bid protests? Or is that something everybody knows about?
Mark, you're really helping me out here. I personally am biased. I think that you should probably get a knowledgeable attorney that does bid protests regularly. Now, I will say, I think that this is an area of law. If you've got a very standard bid protest, it's possible that another attorney who doesn't regularly practice in the area can carry it through for you. I just worry, somewhat similar to, these large language models, that there's going to be little nuances or things that you miss out on. One of the reasons I write, for Surety Bond Quarterly, for instance, is I want to stay abreast of the recent changes in the law. And it's a quickly evolving space. Great example, federal acquisition regulations, the FAR, they're being overhauled right now. It's FAR 2.0, FAR overhaul. Yep. And, while we won't get into that too deeply, I think it's one of those things where they're changing the regulations. They say they're doing it to strip down and simplify. And the way that I often think about the attempts to simplify and rewrite is, well, it's sort of like a hydra. You cut off one head and a couple spring up in its place. And that's because you're breaking decades old precedent, potentially interpretation of the FAR, and you're introducing changes that folks haven't figured out. A great example is, I've got some clients who they refer to FAR 8.7 all the time, the Ability One set-aside procurement program, and they moved it. They didn't change any of the language. It's based on a statute, but they moved it from FAR 8.7 to 8.3.
Well, we were happy to see that FAR 28 was left alone. That's dealing with the bonds. So we were happy about that. But that's a great point about how, particularly now, things are really in a state of flux, and there are a lot of developments happening, particularly in federal procurement.
Yeah. Even though AI might make us feel confident that we can do this on our own, it's probably not a good DIY process.
Don't be confident with AI right now.
and listen, I recognize that I'm coming across as a little bit of a Luddite here, as a little bit of an anti-technology person. I want to assure you that's not at all my position on this. It's just that it has to be used in the right context. It's a tool. It has excellent capabilities. And I think that when used correctly, it can be really effective. So just to help those out there that might be considering a pro se protest, first of all, maybe consider an attorney. But if you insist on filing one yourself, The bare minimum that you can do to avoid a sanction here is to look up all of the citations that it generates for you. And what that means is very simple. And, everybody can do this, because you don't need a specific like legal research tool to find GAO precedent. They have a website. All of their published decisions are on there. So if your LLM spits out a GAO decision and it says this, X, Y, or Z, well, you can look up the decision. You can literally just Google it or go to GAO's website, and you can check, is the case number right? Does it say what the AI says that it says? And and if not, then you need to change it. And that's really the bare minimum.
Trust but verify with AI.
Trust but verify.
Well, David, it's been great having you on and just talking through how AI is changing the way bid protests are going in and what to be wary of in these scenarios. Hopefully we can have you back again sometime, because I know it sounds like this is going to continue to evolve over time as there's more changes to FAR and more changes to how the GAO responds.
Yeah, well, Kat, Mark, it was excellent to be on with you and to talk about this issue. It's become a little bit of a hobby horse of mine, so I was really grateful for the opportunity.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.
Before we go, we just wanted to thank Liberty Mutual Surety again for their generous support in supporting this episode of Let's Get Surety. Liberty Mutual Surety provides contract and commercial bonds for all size companies and contractors around the world. Liberty Mutual is here for you today, tomorrow, together. For more information on Liberty Mutual's breadth of surety products and solutions, visit www.libertymutualsurety.com.